Hello, and welcome to another episode of Law and Sarasota. I'm your host, Adam Tebrugge, and today I'm joined by Shelley Freeland Eddy. Shelley, welcome back to the program.
Thank you.
Shelley, I like to talk with people about their journey to the law. Did you always know that you wanted to be an attorney, or what led you into the legal profession?
I did always know that I wanted to be an attorney. I think from as early as maybe late elementary, early middle school, it was confirmed for me. And I don't remember what the issue or the incident was in my life that led me there, but I remember that early I knew that I wanted to be an attorney. And the reason that I wanted to be an attorney was because I saw the similarities between the written word from a legal perspective and the written word from a biblical perspective. And that may turn some people off in terms of what their beliefs are, and that's not really where I'm trying to go. But what for me was that there was liberty and equality and fairness on both sides. And those two things were important for me, and I saw a similarity between the two. And it was an opportunity to be able to help other people, and that the written word and the law always had a place for all of us somewhere. It was just a matter of finding where we fit within the written word. And so to me, that was interesting, it was exciting, and then you put that into the courtroom in a trial setting, and I was just in my element. And so I love that part of it as well.
Well, let's talk a little bit about your legal career. What kind of work did you pursue after you got out of law school?
Well, actually, I ended up in Florida because my parents moved here after I graduated from law school. I graduated from the University of Kentucky, was admitted to the bar in West Virginia, and practiced in Charleston, and actually started out as an assistant public defender in the juvenile division. So practiced law for about a year defending teens.
Well, Shelley, as a state attorney, you certainly had an awful lot of trial experience.
Yes.
And one overlooked part of trials is the jury selection process. Mm-hmm. I think a lot of people dread getting that jury summons in the mail, but there are those of us who think that it is the highest form of civic duty, other than serving in the military, that we ask of our citizens.
Absolutely.
Why are juries so important in the United States of America?
Juries are so important, in my opinion, is that as a person who stands accused of a crime, it's the closest person to you that is supposed to represent you, that has the right to be an outsider, that is presented with evidence, presented with witnesses, and presented with instructions from the judge that basically equals out the system, that basically gives fairness. And where the evidence supports a conviction, they should convict. Where the evidence supports an acquittal, they should acquit. Where the evidence supports maybe a lesser included charge, then they have the right. But the thing is that they are guided by us as attorneys and by the judge as the arbiter in the courtroom to make sure that the system works.
Shelley, in the state of Florida, for a regular felony trial, we might bring in, say, 30 or 40 jurors. And then we whittle those down to get a group of 6 to 8 citizens to decide the case.
Yes.
Now, one way that we whittle the panel down is what we call challenges for cause. Mm-hmm. Could you tell our viewers a little bit about what a challenge for cause is?
A challenge for cause can basically be any reason, but not a discriminatory reason, that leads you to believe that a person maybe has a bias. Maybe there is a personal relationship with one of the parties, and that includes the judge and the lawyers coming into the proceeding, that they have had a personal experience that's so similar to the one that's being tried that they can't erase their feelings about what they went through versus the evidence and the perceptions that they were received during the trial. And basically, they're biases that prevent an individual from issuing a fair and impartial verdict. And people laugh when you say fair and impartial, because the point is that you've got to pick one side over the other, but you use the same parameters when you're making that decision, and that's what makes it fair and impartial. So in the state of Florida, as attorneys, we get challenges for cause where we can strike jurors for those reasons, and we don't have to give the judge a reason as to why we're striking that person. It's strategy. Basically, as a part of voir dire or jury selection, we introduce the theories of our case, and as a defense attorney, the theories of the defense and possible defenses that are interwoven without, quote, pre-trying the case. And so we lay the groundwork and set the stage, and then instead of selecting, we deselect. We choose people that we believe are not fit for jury service, and we cross those people out. In the peremptory portion, we don't have to give a reason. And the challenge for cause, we do have to give a reason.
And each side, both the state and the defense, gets an equal number of peremptory challenges.
Yes.
You know, I think you made a great point that during the jury selection process, the attorneys are trying to teach the jurors a little bit about their theory of the case. But I'll tell you, my goal in jury selection is I want to try and get to know this person in a very short period of time so I can make the decision as to whether they're a good fit for my particular case.
Absolutely.
What were some of the goals that you took into the courtroom when you were doing jury selection?
That was a similar goal, is getting to know the jurors, determining whether or not there were life issues or situations that prevented them from being fair and impartial. Sometimes there are health issues. Sometimes there are scheduling issues. Sometimes there are employment issues. There are a number of things that can distract the mind of a juror when it comes time to them sitting on your jury. And the worst person that you want is a distracted juror. You know, from a lawyer's perspective, we can't read them because we don't have their full attention. And a lot of times we may think it's because they don't like us, but sometimes they just have other things to do and can't disconnect those other responsibilities. And so from the juror's perspective, it's really invasive because we appear to ask them very personal questions and they don't know us from a can of paint. Why are you talking to me this way? But of course, you and I, we start our introductions and we let them know that I'm going to ask you some very pointed questions. And if I ask you anything that you feel that's inappropriate for you to discuss out loud, we'll go to the judge's bench and you can discuss that privately. But along with, you know, getting to know them, we want to build a rapport. We want them to get to know us. And a lot of times people misjudge when you may appear to be jovial or funny or use a smile. You're trying to build a rapport with the juror. You don't want to seem unprofessional or uncaring, but at the same time, you don't want to be a square peg and they're like, oh my gosh, who is this person? You know, is this person really real? So there's a balance that you have to strike.
Well, Shelley, over at Booker High School, there's an exciting collaboration going on with the Van Wezel Foundation, and they're bringing a performance of the musical Chicago to Sarasota in 2014. And meanwhile, the students over at Booker are studying the play Chicago, which revolves around a high-profile murder trial.
Yes.
Very briefly, what are some of our concerns when we are picking a jury in a high-profile case?
Well, this program, as you mentioned, it's through the Broadway League and the Van Wezel Performing Arts Hall. And a lot of people don't know that the Van Wezel actually has an education and community foundation segment, a community engagement department, where they seek to develop partnerships with education institutions. And because Chicago the Musical is coming to the Van Wezel, and because of the new advent of the Law Academy, they thought that it would be a perfect opportunity for us to put law and education together. And fortunately, we were awarded one of 10 grants in the entire country that was awarded by the Broadway League. And part of what we're talking about in terms of selecting a jury in a criminal high-profile case is that, as you know, a lot of their opinions come from what they read, what they see on TV, what they see in social media, and what they hear from other people. And as attorneys, we have to get rid of all of those things when we try to select a jury, because a lot of times that information may not be accurate, or they only get bits and pieces of the truth. And so we've got to whittle away what those perceptions are to try to figure, is this a person that we can start from scratch and mold them with our theory of the case or of the defense? And in high-profile cases, it's terribly hard to do because they're inundated with it. And especially now with technology, you can tweet it, you can get it on Facebook, you can get it on social media, you can get pictures on Instagram. A lot of times people may go to the courthouse and video footage. You just have no idea how information gets out. And as lawyers, we've got to make sure that we try to insulate the jurors from that process, because they get tainted by what they think is the truth.
Well, Shelley, in the second half of our program, you and I are going to go to Booker High School, and we're going to assume our roles as prosecutor and defense attorney, and go through the jury selection process with the students and hopefully get a great discussion going about some of the concepts that you just talked about.
Absolutely. It's a good chance for them to take control. A lot of times you feel like, even as a juror, that you're just told where to go and what to do, and they actually get to help us perform that role.
So please stay tuned for some more Law and Sarasota as we go to the Booker High Law Academy. What are some of the advantages of having a jury? What do you think an advantage is of having a jury?
An advantage is that they have, like, their peer group, and like they all basically decide if what they did was wrong or right, and it's more fair. It's not like just one point of
That's an outstanding answer. Was everyone able to hear that? The point she was making, and you correct me if I'm wrong, is that collective wisdom is sometimes better than individual judgment. We have a lot of respect for our judges, and we rely on judges to make important decisions every day. Jury trials are relatively rare. If Shelley and I had 100 cases together, maybe only 2 or 3 of those would actually be a jury trial. The rest of the cases could be a plea bargain, or it could be where the judge decides if somebody's guilty or not guilty. But when we have an important case, I know from the defense perspective, I want jurors. I want people from the community. Shelley, what do you think about that as a prosecutor?
Well, I think, like Najee said, it depends on if you get the right jury. The point is that the law says that you are entitled to a jury of your peers if you are accused of a crime. And what that means is that the community gets to weigh in, because in a criminal case, the victim is not necessarily the person who was injured or killed. The victim is really the state of Florida or the Commonwealth of Michigan, or in our case, the Commonwealth of Chicago. It's the community that has been victimized by the acts of Roxy Hart. So in that case, it means that the jury should be allowed to participate in the decision as to whether or not the defendant is guilty or not. The way that it works is that both the Commonwealth, the state, and the defendant have to agree that the case goes before a judge. If they both don't agree, then it comes before a jury. Another issue that comes up as it relates to juries that makes it more complicated is when the media is involved. And we're going to talk about that in instructions. And one of the instructions that you will receive will instruct you that as a juror, you are not to consider what you've heard outside of court, what you've read outside of court, any blogs, any social media, any tweets, anything that's posted on Instagram about a crime. You can't consider those things when you are rendering a decision. Your decision of guilt or innocence must be based only upon the evidence that you hear in this courtroom and the instructions that will be given by our judge. And sometimes the judge gets it wrong. We have cases that have been what's called appealed when the judge gives a wrong jury instruction. If you've heard of the Marissa Alexander case, that was a case in the state of Florida where she gets a new trial because the judge gave the wrong instruction to the jury. So the jury followed what the judge said, but the judge was wrong. So that's an opportunity where the lawyers get to file motions and ask the next court to see whether or not what the lower court did was right. So sometimes you may think it's over, and it's not over. Because in the case of Marissa Alexander, she gets another trial that starts in March of 2014. But she's been in jail for 3 years trying to get her case reheard. So again, it just depends on the jury.
Now, you all were asked a great question to start out this morning, and that is jury selection the most important part of the trial? Before I answer that, let's just talk very briefly about the rest of the trial. What happens after jury selection? What's the first part of a trial after jury selection? Anyone have any ideas? Yes, sir.
All parties are sworn in.
We are going to swear the witnesses under oath. Before we do that, before we hear from the witnesses, who are we going to hear from?
The lawyers.
The lawyers. Now, the state, the prosecutor, the government, the Commonwealth, these are all words we're using to describe this side. The state has the burden of proof. So therefore, the state always goes first in the trial. And the first part of the trial is called opening statements. Shelley, what are you going to try and do in your opening statement?
In my opening statement, I am going to introduce you to me I'm going to explain what my function is. I'm going to thank you for your service in advance. I'm going to give you a summary as to what the state's evidence will be in this case. Before we get to opening statements and jury selection, we will talk about what the burdens of proof are, what your job is, things you can consider and cannot consider. When we get into the opening statement, I will actually walk you through what we believe the proof is going to be in this case. I'm going to give you a laundry list of who our witnesses will be, of what the evidence will show. If there is going to be pictures or statements or video, any evidence that we have, I'm going to give you a summary of that evidence. I'm going to give you a brief summary as to what the law is in the case, and I'm going to ask you at the end of the case to follow the evidence and find the defendant, in this case Roxy Hart, is guilty of the offense of homicide. If there was an issue as to possible defenses, I may or may not raise those defenses. If there were issues with regard to particular witnesses, or if there was going to be a break in the case, something that was unusual, I would give you a heads up about that. So I would give you a roadmap, so to speak, as to where the state was going with our evidence, and hopefully give you no other alternative except for to agree with my position, but that this defendant should be found guilty.
Now, Shelley's a pretty good lawyer, don't you agree? She makes a pretty good impression up here, right? She looks good, she speaks well, she's pretty compelling. So, if I'm going up against Shelley in the courtroom, there's a very good chance I'm going to want to make an opening statement also. Now, here's the funny thing. I don't have to. The defense does not have to do anything. I can sit here throughout the whole trial. I can take a nap. I've even done a trial where I don't have a client, and I'm defending the case without anyone seated next to me. Why don't I have to do anything? Why do you think I don't have to do anything? Well, my client, most of the time my client's going to be here. Yes, sir. That's it. That's it. And did you hear that? Say it louder.
They don't have the burden of proof.
What does that mean?
They don't have to prove anything.
I don't have to prove anything. The sole burden of proof lays with the government. And if you all are ever jurors, our judge up here will make that very clear to you. Now, practically speaking, what's the problem with that? What's the problem with that? If I don't do anything, if I don't say anything, what are you left thinking? Yeah, I don't have anything to say, right? I must not even have a defense if I'm not saying anything. I mean, that's one practical way to look at it, right? Have you ever heard there's two sides to every story? Well, guess what? Not in a criminal case. Not necessarily. So I try and explain that to the jurors as the case starts. And they'll say, oh, okay, I agree with you. You don't have to do anything. The state's got the burden of proof. I agree with you. But in reality, I better do some work, right? I better do my job, especially if I'm going up against a skilled opponent. Now, Shelley gives her opening statement. I give my opening statement. Sometimes I really go into a lot of detail. Other times I say, just please keep an open mind. Pay attention to the witnesses. I'm going to have a lot of questions for these witnesses. So I may not have told my whole story, but hopefully I keep everybody on board. Okay? Well, good morning, everybody. My name is Billy Flynn, and it is my distinct pleasure and great honor to be representing Roxy Hart here this morning. Mr. Davis, when you look at Roxy Hart seated over there, do you think that she is guilty?
I have an opinion.
Why don't you have an opinion?
Because I haven't seen any evidence.
Now listen here, Mr. Davis, and I need you to speak up real loud for me. You read the newspapers, don't you?
Yes.
You watch television, don't you?
Yes.
You've heard all about Roxy, haven't you?
No,
Okay, why not?
I don't read that part.
You don't read that part. Well, I understand, and I thank you for telling me that. How about you? What's your name?
Zach Maxwell.
Zach Maxwell. Well, what do you think about Roxy? Do you think she must be guilty or she wouldn't be here? And speak up real loud for me.
Maybe.
Maybe. Right?
Right.
She might be guilty, right? Do police officers arrest people for no reason at all?
No.
No. Police officers don't usually arrest people for no reason at all. Well, let me ask you this, Miss Marshall. Let's say Roxy Hart took the witness stand, and she was a witness in this case. Are you going to listen to what she has to say?
Yes.
Are you going to pay attention?
Yes.
You're going to treat her like any other witness, right? And that's what it means to have a fair trial, right?
Yes.
You're going to listen to Roxy Hart's story, right? Now, what's your name, ma'am?
Laura.
Say your last name again.
Laura.
Laura. What about this? If I don't call Roxy to the witness stand, what are you going to think about that?
I'm gonna think that you're protecting her.
Okay, is that a good thing or a bad thing?
A bad thing.
A bad thing. Why is it a bad thing?
Because then that will lead me to think that she is guilty.
Okay, that's a very honest response, and I thank you for that very much. You would want to hear from Roxy if you were on the jury, right?
Yes, sir.
And even if the judge told you that she didn't have to testify, it would still bother you, wouldn't it? If Roxy didn't testify, that would bother you, right? You might hold that against her, right? Your Honor, I'm going to have to move to excuse this juror because she would be unable to follow the law of the court.
May it please the court, opposing counsel. Good morning, ladies and gentlemen of the jury. My name is Shelley Freeland Eddy, and along with my co-counsel, Sateria Preston, we represent the Commonwealth of Illinois, and we are here today in the case of the Commonwealth of Illinois versus this defendant, Roxy Hart. As you've heard from the jury instructions in the brief explanation, Roxy Hart was charged with fatally shooting her lover, Fred Casely, a man that she was having an affair with behind the back of her husband. As you will hear in this case, there will be some pretty emotional testimony that will come forth in this case. And as a part of doing our job on behalf of the state of Illinois, we have to ask you some questions. There may be some questions that will be general, and there may also be some questions that will be slightly personal. In the event that we ask you a question that is personal or, in your opinion, too personal to discuss openly, we give you the opportunity to come directly to the judge's bench to discuss your answer privately. So please feel free to do so. Is there anyone here today that has any mental or physical disabilities or impairments that prevents you from giving this case your full attention? And what I mean by that is there anyone that has a doctor's appointment over the next 3 days that knows that they wouldn't be able to be here to attend the court's appearance? Anyone here have any doctor's appointments? Anything that would keep them from being here? What about child care issues? Anyone have any issues where they don't have a babysitter? What about issues with work? Is there anyone here that your boss has told you, I don't care what they said downtown, I need for you to be at work tomorrow, and if you're not here, you're going to lose your job? Anybody have any deadlines? What about you? Any deadlines at work? Tell me, what do you do for a living?
Roofing.
Okay. Got any projects going this week?
No.
Okay. All right. Anyone else have any issues on the job that keeps them from giving this case your full attention? What about you, ma'am?
No.
No issues at home? Anybody here a student? Anybody taking classes? What about you, sir?
Yeah.
Nothing that would prevent you from giving this case your full attention? I saw another hand. Yes, what about you, ma'am?
No.
Okay. All right. As you have heard, and as you came in the courtroom this morning, there were trucks and trucks of media outside that were waiting to figure out what was going to happen in this courtroom today. Has anybody ever heard on TV or on the news about this defendant, Roxy Hart? What have you heard, sir?
That she killed someone.
Okay.
That it did happen.
That it did happen? And what else did you hear?
That's it?
Okay. How many stories have you heard about this case?
5.
5. What was the most recent one?
Last night on the news.
Okay. And what did you hear last night on the news?
Your Honor, if I could have the jurors speak up. We're having trouble hearing them over here.
Sir, if you could just raise your voice just a little, please. You said you heard 5 stories and the most recent one was last night. What did you hear last night on the news about this case?
I heard last night that Roxy Hart was accused of killing someone.
Do you know who?
Her lover.
Okay. What do you think about Roxy having a lover? Do you have any opinions about that?
Well, she was married, so she shouldn't have an affair outside of her relationship, but that's none of my business.
Okay. Let me ask you this. Do you believe that Roxy committed the crime that she's accused of based on what you heard on TV?
I don't have an opinion formulated as of right now.
Okay. You mentioned that she shouldn't be having an affair because she's married. Have you or maybe a family member or a close person or friend ever experienced a situation where a relationship has been broken up because of an affair?
Yes.
If it's not too personal, would you tell me about that?
This is what you
Okay. Your Honor, I think this is relevant. Can we have the witness approach the bench?